Swayam Prabha. Digital India. Educated India.
Namaste. Today we begin a new module which is the CRPC part 2. This module will have 3 lectures: search and seizure, reformative and compensation provisions in the CRPC, and some other important provisions of the CRPC. So let us begin with search and seizure. Now search and seizure are not discussed at one particular place in the CRPC. They are covered in 4 different chapters. We have search and seizure in the case of arrest of persons, as we saw in the last lecture. Then chapter 7 deals with processes to compel the production of things. So even to compel the production of things, there might be a requirement of searching for those things and seizing those things. Then chapter 11 deals with preventive action of the police, which also involves some search and seizures. And chapter 12 deals with information to the police and their powers to investigate. So even during the process of investigation, there might be searches and seizures necessary. So we saw that in the case of chapter 5, arrest of persons, section 47 dealt with search of place entered by person sought to be arrested. And in this case, we have seen in the previous lecture that if the person sought to be arrested has entered into a place, then the police has the power of entering into that place and searching for that person. Now in this case, if the ingress cannot be obtained upon asking, then it is lawful for the person who is going to arrest to break open any of the doors or windows, so that they have an ability of getting inside. Provided that if the place is being occupied by a female, then the police is going to respect the customs and permit the female before entering the apartment to withdraw and afford her every reasonable opportunity and facility for withdrawing. Then if a person has entered into a house and then if something happens, the doors are closed, then the person to get out also has the power of breaking any door or window to liberate themselves or any other person. Then section 51 dealt with the search of the arrested person. So if a person has been arrested by a police officer under a warrant which does not provide for the taking of bail, or under a warrant which provides for the taking of bail but the person cannot furnish bail, or when a person is arrested without warrant or by a private person under warrant and cannot legally be admitted to bail or is unable to furnish the bail. So in those cases, the police has the power to search the person and everything will be taken away from that person other than the clothes that the person is wearing. So apart from that, everything will be seized, it will be kept in a safe custody, and then a receipt will be made and given to that person that such and such things have been seized from you. And when this person is released, these items are then given back. So this is search of an arrested person. And whenever a female is to be searched, then all arrangements are made so that the decency is maintained, and these arrangements include search to be made by another female only. Then we saw in section 52 that the police also has the power to seize offensive weapons. So when an arrest is being made and there are offensive weapons with the person, then those weapons are then seized. So this is regarding the powers of search and seizure when an arrest is going on. So the police has the power to search any premises, enter into any premises to search for the person, and once a person has been arrested and is not being released on bail, so in that case the body of the person is searched and everything apart from the clothes are taken away, they are seized, and a receipt is given to that person, and these items will be handed back when the person is released. Then third, we saw that if there are any offensive weapons with the person, then those offensive weapons will also be seized. And in all cases, there are procedures that the CRPC maintains that if you want to enter into any building, then you will first of all you will take permission of the person who has the authority of that apartment or house, and if that person does not permit you, then the police has the power to break open the doors and windows and get inside. While getting inside, the customs as they relate to females, they will be observed and they will be afforded the opportunity to withdraw themselves if they do not want to expose themselves to the public or to the police. And then we also saw that when the police has entered inside, and then if a situation arises that they are unable to come out, then too they have the power to break any door or window to be able to get out. So in all these cases, there are searches whether for person or for things, and there are also seizures regarding the items that are there with the arrested person or the offensive weapons that are there with the arrested person. Next, chapter 7 deals with processes to compel the production of things. Now in this case, section 91 talks about summons to produce document or other thing. Whenever any court or any officer in charge of a police station considers that the production of any document or other thing is necessary or desirable for the purposes of any investigation, inquiry, trial or other proceeding under this code, by or before such court or officer, such court may issue a summons or such officer a written order to the person in whose possession or power such document or thing is believed to be, requiring him to attend and produce it or to produce it at the time and place stated in the summons or order. Now, what is this section saying? That in the case of any investigation, and we have seen before that investigation is done by the police, or inquiry that is done by the judiciary, or trial that starts after the inquiry ends, or any proceeding under this code. In any of these, if it is necessary or desirable, so it may just be desirable, not necessary, then too the authorities have the power. And what is the power? The court may issue a summons and the officer may issue a written order. So summons are issued by the police, by the court, and written order are issued by the officers. And these summons or the written orders are directed to the person in whose possession or power that document or thing is believed to be, and requiring him to attend and produce it or to produce it. So it may either ask that person to come and produce that document or thing, or just to produce that document or thing at the time and place stated in the summons or order. Any person required under this section merely to produce a document or other thing shall be deemed to have complied with the requisition if he causes such document or thing to be produced instead of attending personally to produce the same. So if the summons or the order is just asking to produce the document, is not asking to attend and produce, it's just saying produce the document or thing, and if the person does not come himself and sends this thing and causes the document or thing to be produced, then it is deemed that he has produced the document or thing. He does not have to come personally. Then section 92 deals with procedure as to letters and telegrams. If any document, parcel or thing in the custody of a postal or telegraph authority is, in the opinion of the district magistrate, chief judicial magistrate, court of session or high court, wanted for the purpose of any investigation, inquiry, trial or other proceeding. So all four of these. Such magistrate or court may require the postal or telegraph authority, as the case may be, to deliver the document, parcel or thing to such person as the magistrate or court directs. So if the thing is either a letter or a telegram, then the magistrate or the court can then write to the authority, in this case the postal or the telegraph authority, to deliver that document, parcel or thing to such person as is directed. So even if the things are with the postal department or the telegraph department, then too they will have to be provided. If such document, parcel or thing is, in the opinion of any other magistrate, whether executive or judicial, or of any commissioner of police or the district superintendent of police, wanted for any purpose, he may require the postal or telegraph authority, as the case may be, to cause search to be made for and detain such document. So, they can even ask the postal and telegraph authority to cause a search to be made for that document, parcel or thing, and then detain that document, parcel or thing, pending the order of a district magistrate, the CJM or the court under subsection 1. Then when search warrant may be issued. Now, in a large number of cases, before a person makes a search, then a search warrant may be required. So, when a search warrant may be issued, when any court has reason to believe that a person to whom a summons under section 91 or a requisition under subsection 1 of section 92 has been or might be addressed, will not or would not produce the document or thing as required by such summons or requisition. So, if the court has reason to believe that when they issue the summons order or a requisition under section 91 or 92, the person will not produce it, or they have already issued the summons or a requisition order and the person has not produced that document or a thing, or where such document or thing is not known to the court to be in the possession of any person. So, when the court does not know who has the possession of that document or thing, so it has to be searched for, or where the court considers that the purposes of any inquiry, trial or other proceeding, not an investigation here, under this code will be served by a general search or inspection. So, it can also ask for a general search or inspection of the area. It may issue a search warrant, and the person to whom such warrant is directed may search or inspect in accordance therewith and the provisions hereinafter contained. So, in these three cases, a search warrant may be issued. Now, the court may, if it thinks fit, specify in the warrant the particular place or part thereof to which only the search or inspection shall extend, and the person charged with the execution of such warrant shall then search or inspect only the place or part so specified. So, the court may specify which is the place to be searched or which part of the place is to be searched, and then the person who is executing this warrant is only going to search that particular place or the part thereof. So, the search warrants are not general documents, they are very specific documents. So, if the court thinks fit, it may specify these. If the court thinks that a general search is required, only in those cases it will issue a general search warrant. Now, nothing contained in this section shall authorize any magistrate other than a district magistrate or the CJM to grant a warrant to search for a document, parcel or other thing in the custody of the postal or telegraph authority. So, in the case of postal or telegraph authority, they can only write to the authority, they cannot do a search of their offices or premises. Then section 94 talks about search of place suspected to contain stolen property, forged documents, etc. If a district magistrate, SDM or magistrate of the first class, upon information and after such inquiry as he thinks necessary, has reason to believe that any place is used for the deposit or sale of stolen property, or for the deposit, sale or production of any objectionable article to which this section applies, or that any such objectionable article is deposited in any place, he may by warrant authorize any police officer above a rank of a constable. So, in these cases where the place is suspected to contain stolen property, forged documents or other things as are specified later on in this section, the district magistrate or the SDM or the magistrate of first class can issue a warrant, and this warrant will authorize any police officer above the rank of a constable to enter with such assistance as may be required such place. So, when it says with such assistance as may be required, it means that they can also carry force with them so that they are able to enter that place. Then to search the same in the manner specified in the warrant. To take possession of any property or article therein found which he reasonably suspects to be stolen property or objectionable article to which this section applies. So, take possession is basically they can seize any property or article which they reasonably suspect to be stolen property or objectionable article. To convey such property or article before a magistrate or to guard the same on the spot until the offender is taken before a magistrate or otherwise to dispose of it in some place of safety. To take into custody and carry before a magistrate every person found in such place who appears to have been privy to the deposit, that is who appears to have been either in knowledge of or a part of the deposit, sale or production of any such property or article, knowing or having reasonable cause to suspect it to be stolen property, or as the case may be, objectionable article to which this section applies. So, the search warrant can give all of these powers. Then subsection 2 says the objectionable articles to which this section applies are counterfeit coin, pieces of metal made in the contravention of the Metal Tokens Act or brought into India in contravention of any notification for the time being in force under section 11 of the Customs Act, or counterfeit currency note, counterfeit stamps, forged documents, false seals, obscene objects referred to in section 292 of the IPC, instruments or materials for the production of any of these articles. So, in case these articles are believed to be there in some place, then the DM or the SDM or the magistrate of first class can issue a search warrant giving all these powers to any police officer above the rank of a constable, and then these articles can be searched for and then seized. So, here again we are looking at search and seizure. Then section 95 talks about power to declare certain publications forfeited and to issue search warrants for the same. So, this applies to certain publications. Publications means newspaper, book or any document. So, where any newspaper or book or any document wherever printed appears to the state government to contain any matter the publication of which is punishable under section 124A or section 153A or section 153B or section 292 or 293 or 295A of the IPC. The state government may by notification stating the grounds of its opinion declare every copy of the issue of the newspaper containing such matter and every copy of such book or other document to be forfeited to the government. Now, forfeited means that it becomes vested to the government, it becomes a government property, it no longer remains with that person, and thereupon any police officer may seize the same wherever found in India, and any magistrate by warrant authorize any police officer not below the rank of sub-inspector to enter upon and search for the same in any premises where any copy of such issue or any such book or other document may be or may be reasonably suspected to be. So, when any newspaper, book or document is printed and it contains matters that are punishable under these sections of the IPC, then the state government may by notification. So, in this case there has to be a notification by the state government stating the grounds of its opinion. So, it is not that the state government can just say that okay, this book is forfeited. No, they have to state the grounds. Why do they think so that it violates these provisions? So, the state government may by notification stating the grounds of its opinion declare every copy of the issue of the newspaper containing such matter and every copy of such book or other document to be forfeited to the government. Now, once this notification has been issued and these documents are forfeited to the government, then any police officer, no matter the rank, he may seize the same wherever it is found in India, and any magistrate may by warrant authorize any police officer not below the rank of SI to enter upon and search for the same in any premises where any copy of such issue, book or document may be or may be reasonably suspected to be. So, if there is a reasonable suspicion that this book, newspaper or document is placed in this particular location or such premises, then magistrate may issue a warrant to search for that premises for these documents. If this now it says in this section and in section 96, newspaper and book have the same meaning as in the Press and Registration of Books Act. Document includes any painting, drawing or photograph or other visible representation. So, all of these are documents. It is not just typed document or written documents. It also includes paintings, drawings, photograph or other visible representation. Now, it says document includes, meaning that apart from these, it can also include other things as well. Now, no order passed or action taken under this section shall be called in question in any court otherwise than in accordance with the provisions of section 96. Then section 97 talks about search for persons wrongfully confined. So, if a person has been wrongfully confined by an offender, then there can be a search made for those persons as well. If any district magistrate, SDM or magistrate of the first class has reason to believe that any person is confined under such circumstances that the confinement amounts to an offence, that is, there is a wrongful confinement of the person, the confinement is an offence, he may issue a search warrant and the person to whom such warrant is directed may search for the person so confined, and such search shall be made in accordance therewith, and the person, if found, shall be immediately taken before a magistrate who shall make such order as in the circumstances of the case seems proper. So, if a person has been, say, kidnapped or wrongfully confined, then these search warrant may be issued, and this search warrant may be issued by the DM, the SDM or magistrate of the first class to search for this person and rescue this person. Then section 98 talks about power to compel restoration of abducted females. We have a separate section for abducted females. Upon complaint made on oath of the abduction or unlawful detention of a woman or a female child under the age of 18 years for any unlawful purpose, a district magistrate, SDM or magistrate of the first class may make an order for the immediate restoration of such woman to her liberty or of such female child to her husband, parent or guardian or other person having the lawful charge of such child, and may compel compliance with such order using such force as may be necessary. Now, in this case, the use of force is also permitted. So, this is again another search that is made. So, in this case as well, there will be a search for this abducted female, and once she is found, then she will be immediately restored to her liberty, or she will be given to the husband, parent, guardian or other person having the lawful charge of her. And in this case, the use of force is also permitted. Then section 100 talks about persons in charge of closed place to allow search. Now, so far we have talked about the powers. Now, this is talking about the duty. So, person in charge of a closed place has to allow search. It is a duty of that person. If he does not do that, then he or she is committing an offence. Whenever any place liable to search or inspection under this chapter is closed, any person residing in or being in charge of such place shall, on demand of the officer or other person executing the warrant and on production of the warrant, allow him free ingress thereto and afford all reasonable facilities for a search therein. So, if the premise is a closed place, that is, it has doors and it has been closed. So, the person who is residing there or is in charge of that place will, on demand of the officer or other person executing the warrant and on production of the warrant. So, in this case, the production of the warrant is necessary. The person can ask for a warrant, show me the warrant by which you are authorized to come into this place and search. And if the warrant is produced to that person, then this person has to allow the person executing the warrant free entry. Ingress means entry, free entry into the property and afford all reasonable facilities for a search therein. If ingress into such place cannot be so obtained, the officer or other person executing the warrant may proceed in the manner provided by subsection 2 of section 47. So, in that case, he may use force and break into that area. Where any person in or about such place is reasonably suspected of concealing about his person any article for which search should be made, such person may be searched, and if such person is a woman, the search shall be made by another woman with strict regard to decency. So, if there is a suspicion that the officers have come to this place and the person who is in charge or is residing in that place, if it is suspected that that person himself or herself is concealing the article for which the search is being made, then this section also authorizes the officers to search that person. Given that if the person is a woman, then decency has to be observed. Before making a search under this chapter, the officer or other person about to make it shall call upon 2 or more independent and respectable inhabitants of the locality in which the place to be searched is situated, or of any other locality if no such inhabitant of the said locality is available or is willing to be a witness to the search, to attend and witness the search, and may issue an order in writing to them or any of them to do so. So, whenever these searches are conducted, then there need to be witnesses, at least 2 witnesses, and generally these witnesses are taken from the respectable members of the society in that locality. And if no such member is residing in the locality, if there is an area that is very far off from any other habitation, then the police may request any other person. So, any respectable person living in certain other locality. If they are willing, then they may also be asked to come and help in the search as witnesses. Now, it says further that the search shall be made in their presence. The whole of the operation has to be done in their presence, and a list of all things seized in the course of such search and of the places in which they are respectively found shall be prepared by such officer or other person and signed by such witnesses. So, the search has to be made in the presence of the witnesses, and what is found and where it was found, it is written down and it is signed by such witnesses. But no person witnessing a search under this section shall be required to attend the court as a witness of the search unless specifically summoned by it. So, it does not mean that if you are a witness, then you will have to go to the court again and again. No, it says that if you are a witness, then you shall not be required to attend the court as a witness of the search unless specifically summoned by it. Unless the court specifically summons you, only in those cases you can be called, otherwise you are not required to attend the court again and again. The occupant of the place searched or some person in his behalf shall in every instance be permitted to attend during the search. So, the occupant of the place or his representative shall be permitted to attend during the search if they want to, and a copy of the list prepared under this section signed by the said witness shall be delivered to such occupant or person. When any person is searched under subsection 3, a list of all things taken in possession of shall be prepared and a copy thereof shall be delivered to such person. So, whenever a person is being searched, then all the things taken into possession, a list is prepared for that and a copy is given to that person. A person who without reasonable cause refuses or neglects to attend and witness a search under this section, when called upon to do so by an order in writing, delivered or tendered to him shall be deemed to have committed an offence under section 187 of the IPC. So, if you are given this order in writing, then you are required to be a witness or you are required to attend the search. Otherwise, the police will not have any person to say to agree to be a witness. This is why this clause has been included, that if the person is called upon to be a witness under a written order, then the person has to be a witness, if they do not have any other reasonable or justifiable cause. So, it is not that if you are in an emergency and the police is asking you to be a witness, you cannot say no. You can say no, but if you do not have an emergency, then you need to cooperate with the police and be a witness. Now, section 101 says disposal of things found in search beyond jurisdiction. When in the execution of a search warrant at any place beyond the local jurisdiction of the court which issued the same, any of the things for which search is made are found, such things together with the list of the same prepared under the provisions hereinafter contained shall be immediately taken before the court issuing the warrant, unless such place is nearer to the magistrate having jurisdiction therein than to such court, in which case the list and things shall be immediately taken before such magistrate, and unless there be good cause to the contrary, such magistrate shall make an order authorizing them to be taken to such court. So, whenever the search is made, the things that are seized and the list of those things, they have to be taken either to the court that had issued the search warrant, or if that court is far away and the place is nearer to another magistrate, then that those things and the list can be taken to the magistrate that is having the jurisdiction and is close by. And in these cases, the magistrate, unless there is a good cause to the contrary, will make an order authorizing them to be taken to the court that issued the search warrant. So, basically, whenever a search is made, whenever things are seized, then the things and the list of the things, they have to be immediately taken to the court, or if they cannot be taken to the court that issued the summons, then they have to be taken to a nearby court, a nearby magistrate. And as little time as possible should be expended in this process. So, we'll find that the CRPC is trying to speed up things at every instance. It is trying to ensure that the procedures are such that there are very little chances then that things can be tinkered into. So, for instance, if the police officer takes a very undue long period of time, then somebody can put a blame that okay, this person has added a few things into the things that were seized and has also written a few things in the list. Now, to overcome all of these things, it is saying that no, the police officer has to take it to the nearby magistrate. If the court is very far away, then take it to the nearby magistrate and then the magistrate will make an order, so that there is very little chance of tampering with any of the things. Then section 102 says power of police officer to seize certain property. Any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offence. So, if there is a suspicion of commission of any offence, or a thing is suspected to be a stolen property, then any police officer may seize that property. Now, in this case, the police officer does not need a warrant. He or she may directly seize that particular property which is involved in an offence such as theft. Now, such police officer, if subordinate to the officer in charge of a police station, shall forthwith report the seizure to that officer. So, he has to report it to his superior officer in charge of the police station. Every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction, and where the property seized is such that it cannot be conveniently transported to the court, or where there is difficulty in securing proper accommodation for the custody of such property, or where the continued retention of the property in police custody may not be considered necessary for the purpose of investigation, he may give custody thereof to any person on his executing a bond, undertaking to produce the property before the court as and when required, and to give effect to such further orders of the court as to the disposal of the same. That is, when the police officer has seized any property, then then that seizure has to be reported to the magistrate having jurisdiction in that area. And then if the property is such that it cannot be conveniently transported, or it is difficult to secure proper accommodation of custody, or if continued retention is not necessary for the investigation, then the police may give the custody of the articles to any person on his executing a bond, undertaking to produce the property before the court. So, what we normally do is that if we have seized the property from someone, we will make the list, we will take photographs, and then we will give these items back to that person on a bond. Now, this bond will say that I hereby agree to bring these items to the court as and when I am called to do so. So, in that case, the authorities do not have to keep those items with them at all times. So, it becomes easier. Then it continues by saying that provided that where the property seized under subsection 1 is subject to speedy and natural decay, and if the person entitled to the possession of such property is unknown or absent. So, you cannot give this property to the person who is entitled to the possession, because that person himself is unknown or absent, and the property is such that it is subject to speedy and natural decay, and the value of such property is less than 500 rupees, then it may forthwith be sold by auction under the orders of the SP. And the provisions of sections 457 and 458 shall, as nearly as may be practicable, apply to the net proceeds of such sale. Now, what is this 457 and 458? Well, we have seen before that in the case of those articles that are subject to a speedy decay, then the magistrate may order that these things should be sold off in an auction and the proceeds kept, and then when the case is decided, then whoever should have gotten this property will get the proceeds in lieu thereof. So, if the property is to be confiscated, it has to be made a government property, then the government will get that money. If it turns out that no, the accused person has not done anything wrong, he is not an offender, and the property legitimately belongs to him, then that money is given to that person, because the court proceedings may take time. Now, here it is saying that if the value of the item is less than 500 rupees, then it is not necessary to approach a court and get this order. If the value of the item is less than 500 rupees, then the SP himself can direct that it should be sold in an auction, and then the proceeds dealt with in the same manner. Then section 103 talks about magistrate may direct search in his presence. Any magistrate may direct a search to be made in his presence of any place for the search of which he is competent to issue a search warrant. So, when the magistrate is competent to issue a search warrant, he may also direct that the search should be made in his presence. That is a power with the magistrate. Then power to impound document etc. produced. Any court may, if it thinks fit, impound any document or thing produced before it under this code. So, when you say impounding a document or a thing, it means that that particular thing will remain in the custody of the court or of the authorities till the court says that it can be released. So, that is the process of impounding, and any court may, if it thinks fit, impound any document or thing produced before it under this code. This is a very vast power. Then section 105 talks about reciprocal arrangements regarding processes, where a court in the territories to which this code extends desires that a summons to an accused person, or a warrant for the arrest of an accused person, or a summons to any person requiring him to attend and produce a document or other thing, or to produce it, or a search warrant issued by it shall be served or executed at any place within the local jurisdiction of a court in any state or area in India outside the said territories. It may send summons or warrant in duplicate by post or otherwise to the presiding officer of that court to be served or executed, and where any summons referred to in clause A or clause C has been so served, the provisions of section 68 shall apply in relation to such summons as if the presiding officer of the court to whom it is sent were a magistrate in the said territories. That is, if the court wants any of these things to be served and it is outside their jurisdiction, then they can send it to another court and then it will get served. In any country or place outside India, in respect of which arrangements have been made by the central government with the government of such country or place for service or execution of summons or warrant in relation to criminal matters. Now, here it is only in criminal matters, not in civil matters. Hereinafter in this section referred to as contracting state, it may send such summons or warrant in duplicate in such form directed to such court, judge or magistrate and sent to such authority for transmission as the central government may by notification specify in this behalf. So, the orders and the warrants and the summons, they can also be served outside India if there is a provision, if there has been an arrangement with another country. Where a court in the said territories has received for service or execution a summons to an accused person or a warrant for the arrest of an accused person, or a summons to any person requiring him to attend and produce a document or other thing, or to produce it, or a such warrant issued by a court in any state or area in India outside the said territories, a court, judge or magistrate in a contracting state, then it shall cause the same to be served or executed. Then that particular court will cause the same to be served and executed as if it were a summons or warrant received by it from another court in the said territories for service or execution within its local jurisdiction. And where a warrant of arrest has been executed, the person arrested shall, so far as possible, be dealt with in accordance with the procedure prescribed by section 80 and 81, and a search warrant has been executed, the things found in the search shall, so far as possible, be dealt with in accordance with the procedure prescribed by section 101. Provided that in case where a summons or search warrant received from a contracting state has been executed, the documents or things produced or things found in the search shall be forwarded to the court issuing the summons or search warrant through such authority as the central government may by notification specify in this behalf. So, what it is saying is, when a search or seizure is required and it is to be done in any other territory outside the jurisdiction of the court, maybe even in another country, then too we have arrangements in which this court will write to the court in that location and that court will serve the summons or warrant or order and so on. And then things will be dealt with as if the court here had jurisdiction in that area. Provided that in the case of other countries, the central government may by notification say that okay, this is the procedure to be followed. So, that is a caveat that is available here. Then chapter 11 deals with preventive action of the police. Now, so far we were talking about an offence that has happened, but then for the preventive action to prevent the offences from happening, also the police has the power of search and seizure as mentioned in section 153. Inspection of weights and measures. Any officer in charge of a police station may, without a warrant, this is important here, without a warrant, enter any place within the limits of such station for the purpose of inspecting or searching for any weights or measures or instruments for weighing used or kept therein, whenever he has reason to believe that there are in such places any weights, measures or instruments for weighing which are false. And if he finds in such place any weights, measures or instruments for weighing which are false, he may seize the same and shall forthwith give information of such seizure to a magistrate having jurisdiction. So, in these cases, to prevent the commission of the offence of a false weight being used, the police has the power to enter into any place and search it, even without a warrant, and even to seize the false weights or instruments that are found there, provided that whenever this search and seizure is done, then it has to be reported to a magistrate. So these are the preventive powers of police, and they also involve search and seizure. Then chapter 12 deals with information to the police and their powers to investigate. So section 165 talks about search by police officer. Whenever an officer in charge of a police station or a police officer making an investigation has reasonable grounds for believing that anything necessary for the purposes of an investigation into any offence which he is authorized to investigate may be found in any place within the limits of the police station of which he is in charge or to which he is attached, and that such thing cannot in his opinion be otherwise obtained without undue delay, such officer may, after recording in writing the grounds of his belief and specifying in such writing, so far as possible, the thing for which the search is to be made, search or cause search to be made for such thing in any place within the limits of such a station. So if it is within the limits of the station and the officer in charge of the police station or a police officer making an investigation has reasonable grounds to believe that something that is necessary for the investigation into an offence which he is authorized to investigate, it may be found in a place within the limits of the police station, and it cannot in his opinion be otherwise obtained without undue delay. So if he does not search and seize that thing, then perhaps it will be too late. It cannot otherwise be obtained without undue delay. It will cause an undue delay if he does not just go there and seize that object, search and seize. Then such officer may, after recording in writing the grounds of his belief and specifying in such writing so far as possible the thing for which search is to be made, search or cause search to be made for such thing in any place within the limits of such a station. So these are very wide powers, with the only restriction that these searches can only be made after recording and writing the grounds of the belief and specifying what needs to be searched. So it's not that the police officer can go anywhere, search for anything and then write down. No, he first has to make an entry about why he has reason to believe that these things are in such places, and that otherwise it will become an undue delay, and what has to be searched for. Only after writing that can he proceed and do the search. Now a police officer proceeding under subsection 1 shall, if practicable, conduct the search in person. That is, that police officer has to conduct the search himself. If he is unable to conduct the search in person and there is no other person competent to make the search present at the time, he may, after recording in writing his reasons for so doing, require any officer subordinate to him to make the search. So he can even delegate this responsibility to any officer subordinate to him if he is unable to conduct the search in person. Specifying the place to be searched and so far as possible the thing for which the search is to be made, and such subordinate officer may thereupon search for such thing in such place. So it can be delegated to a subordinate officer in writing, and this order must specify the place to be searched and what needs to be searched. The provisions of this code as to search warrants and the general provisions as to searches contained in section 100 shall, so far as may be, apply to a search made under this section. So the other provisions are going to apply here as well. Copies of any record made under subsection 1 or subsection 3 shall forthwith be sent to the nearest magistrate empowered to take cognizance of the offence, and the owner or occupier of the place searched shall on application be furnished free of cost with a copy of the same by the magistrate. So these are the saving provisions. All of these records must be sent to the magistrate, and the owner or the occupier of the place that has been searched if he makes an application to the magistrate, he has to be given a copy of this record free of cost. Then section 166 deals with when officer in charge of police station may require another to issue search warrant. An officer in charge of a police station or a police officer not being below the rank of SI making an investigation may require an officer in charge of another police station, whether in the same or a different district, to cause search to be made in any place in any case in which the former officer might cause such search to be made within the limits of his own station. So, the officer in charge of a police station or another police officer not below the rank of SI can ask the officer in charge of another police station, whether in his same district or in another district, to cause search to be made. Now, such officer on being so required shall proceed according to the provisions of section 165 and shall forward the thing found, if any, to the officer at whose request the search was made. So, the search can also be done at other places by taking the help of other police officers. Whenever there is reason to believe that the delay occasioned by requiring an officer in charge of another police station to cause a search to be made under subsection 1 might result in evidence of the commission of an offence being concealed or destroyed. So, there can also be situations where if you go with this route specified in subsection 1 asking another police station to do the search, if you go by that route, the evidence of the commission of the offence may get concealed or destroyed. So, there may be a destruction of evidence or a concealment of evidence. It shall be lawful for an officer in charge of a police station or a police officer making any investigation under this chapter to search or cause to be searched any place in the limits of another police station in accordance with the provisions of section 165 as if such place were within the limits of his own police station. So, if there is reason to believe that if you go through this procedure, then it will cause undue delay and the evidence might get concealed or destroyed, then the officer in charge of the police station or a police officer making any investigation can directly go and proceed to search in the area of another police station as if the place were within the limits of his own police station. And any officer conducting a search under subsection 3 shall forthwith send notice of the search to the officer in charge of the police station within the limits of which such place is situate. So, after the search, the officer who has conducted the search is required to send a notice of the search to the officer in charge of the police station of that place, and shall also send with such notice a copy of the list, if any, prepared under section 100, and shall also send to the nearest magistrate empowered to take cognizance of the offence copies of the records referred to in subsection 1 and 3 of section 165. And the owner or occupier of the place searched shall on application be furnished free of cost with a copy of any record sent to the magistrate under subsection 4. Meaning that the powers of search and seizure are very wide, they are very vast. The police officer can also take the help of another police officer in another jurisdiction to perform the search, or he may directly go to another jurisdiction and do the search if he has reason to believe that if he does not do so, then the evidence may get concealed or destroyed. The only caveat being that this police officer who is doing the search has to, after the search is done, as soon as possible, he has to send a notice that I have done this search and these things were found to the police station that has jurisdiction in that area and to the magistrate. So, throughout this lecture we have found that the powers of search and seizure are very wide, for the courts as well as for the police. Now, when you have such wide powers and when if a search is conducted into your property and something is found which incriminates you, and we have seen before that in the constitution we have a provision that a person cannot be asked to be a witness against himself. So, he cannot be asked to incriminate himself. So, aren't these powers getting a bit on the loggerheads. That is, if I as a police officer, if I enter into your area, into your house, and I want to search for things, then the provisions are saying that you will have to help me out. You will have to give me all assistance that is required. So in that case, am I not asking you to incriminate yourself? So this is a question that was answered by the Honorable Supreme Court of India in MP Sharma and others versus Satish Chandra, District Magistrate of Delhi and others. So the Honorable Court said a search and seizure is only a temporary interference with the right to hold the property searched and the articles seized. So it's not permanent, it's only a temporary interference. Statutory recognition in this behalf is a necessary and reasonable restriction and cannot per se be considered to be unconstitutional. A compelled production of incriminating documents by a person against whom a first information report or an FIR has been made is testimonial compulsion within the meaning of Article 23 of the Constitution. But a search and seizure of the document under the provisions of sections 94 and 96 of the CRPC is not a compelled production thereof within the meaning of Article 23 and hence does not offend the said article. Now, what is Article 23? Article 23 says, no person accused of any offence shall be compelled to be a witness against himself. No person who is accused of any offence shall be compelled to be a witness against himself. You cannot be asked to incriminate yourself. And the Honorable Court is saying that a compelled production of an incriminating document by a person against whom an FIR has been made is a testimonial compulsion within the meaning of Article 23. So you cannot ask that person to produce the incriminating documents against himself. But a search and seizure of the document under the CRPC is not a compelled production. So in this case, you are not compelling the person to be a witness against himself. You are doing a search for that document and you are seizing that document. So it does not offend Article 23 of the Constitution. A power of search and seizure is, in any system of jurisprudence, an overriding power of the state for the protection of social security, and that power is necessarily regulated by law. When the constitution makers have thought fit not to subject such regulation to constitutional limitations by recognition of the fundamental right to privacy, analogous to the American Fourth Amendment, there is no justification for importing into it a totally different fundamental right by some process of strained construction. That is, the Honorable Court is saying that when the framers of the Constitution did not include this safety that there will be no search and seizure, so we cannot include this as a fundamental right just by a strained construction. So the Honorable Court has clearly said that the powers of search and seizure, no matter how vast they are not offending Article 23 because they are not asking a person to be a witness against himself. This is a very different process. So in this lecture, we looked at different chapters that deal with search and seizure provisions for different categories of people. People who are to be arrested, people who have been arrested, things that need to be searched, preventive actions and so on. So that's all about search and seizure. Thank you for your attention. Jai Hind.